Welcome to San Antonio Injury and Employment Law Podcast.
Welcome back to the San Antonio Injury and Employment Law Podcast with Trey Cammack, founder of Cammack Law PLLC. Trey is a personal injury attorney based in San Antonio who helps individuals and families navigate serious injury cases with clear, practical approach. I'm Evan Mack, and today we're focusing on what it's really like dealing with insurance companies after an injury and what people should understand before they say or even sign anything. Trey, welcome, brother.
Thanks, Evan. Good to see you again.
Good to see you too. So, Trey, after an accident, how quickly do insurance companies typically get involved in what usually prompts that first contact?
Yeah, oftentimes the insurance company is involved within 24 hours of the accident. Usually either the other driver calls their insurance or you call your insurance. Your insurance, if you have underinsured motorist coverage or uninsured motorist coverage. So if you have an insurance policy that says if someone hits me and they're uninsured, or if someone hits me and they're underinsured, and that's very common in South Texas and Central Texas for people to be uninsured or to have what's called a minimum policy. Minimum policy being a policy that has $30,000 per person, up to $60,000 for people in the vehicle. Your policy will cover that. Your insurance company, if you call them, should be interacting with the other insurance company. But that driver, if they have insurance, usually calls theirs, and their insurance company reaches out. Sometimes, obviously, people are exchanging insurance at the scene of the wreck. You can also interact with their insurance. But when the insurance company calls you, kind of what I've indicated in a previous episode is that they may ask for a recorded statement. Do not provide a recorded statement to someone else's insurance. And they may be asking to go ahead and get you to sign some type of settlement release or other information. At that point, when that starts happening, you need to get a lawyer involved.
So during that first conversation, what is the insurance adjuster actually trying to accomplish from their side?
So insurance companies are a business. They are very much focused on what is their shareholders and the return to their shareholders, which creates a conflict of interest between covering you and your injury and their bottom line, which is profit. So in the 1990s, Allstate got in trouble because there was information that came forward that they actually had hired a company to go through and develop what they call the good hands boxing gloves approach. And so what it was uncovered in lawsuits and discovery that Allstate tried to hide is that they internally had decided if you were someone who would take lowball offers and settle your case for nominal amounts below what your case was worth, they would give you the good hands approach. Allstate, you're in good hands that they always advertise. But anybody that said, we want more money, we want to hire a lawyer that approached them aggressively and actually wondered what their case is worth, they would approach them with boxing gloves. And that's actually what they called their policy, the good hands boxing glove approach. So the problem with that is still today Allstate's mentality. Allstate, in fact, is one of the worst offenders of the major insurance companies. Allstate does this approach where they use an internal system that was called Colossus. There's different iterations of it. Other insurance companies use some type of software development or analysis. There's Colossus One. There's different versions that are similar to it, where it just inputs what are called medical codes or ICD codes or different codes from your medical bills. So if you have a concussion, it'll be coded this way. If you have a tear to your left knee and it looks like it's a meniscus tear, it's coded this way. If you got an injection in your back, it's coded this way. And so it'll spit out these numbers and they can tweak it to where it makes it valued at a lot lower value. Different insurance companies can do that. And so what they do is they plug these numbers in to spit out these lowball offers, and then they incentivize their adjusters to contain any leakage or contain any offers above what would be a normal amount. There's even a book on this by, I believe, is a Rutgers professor. I forget his name, but the name of the book is Delay, Deny, Defend, where the strategy of the insurance company is to delay the process. So you'll take a lower offer or you will get tired of the process wearing down after a while and just give in. Deny your claims in general or defend them. And that was an analysis of a lot of data that professor had gathered over the years. So, your adjuster is not a villain per se, just because the industry is structured that way, but the industry is structured for shareholder profit, not for your injuries to be paid out. So that adjuster, while doing their job, is not necessarily to your benefit, and they're certainly not in your corner if they're not going to make a reasonable offer.
A lot of people assume the insurance company is there to help, kind of like you were saying, but how does that compare to how these claims are, actually handled behind the scenes, things that people don't see?
Yeah, I mean, in theory, they are supposed to be the help, right? If I work for a company and they have an HR, I hope that HR, when I make a report of something happening, that they do the right thing. That's what
Yeah.
HR is supposed to do. And the insurance company is supposed to take your money. As opposed to me creating a savings account, the insurance company tells you, hey, look, give us money every year for years and years and years. If something happens, we'll take care of it, right? We'll evaluate it. We'll make sure you're in good hands, or as their other advertisements, like a good neighbor, or, all the other advertisements, they spend a lot of money letting you know that, hey, look, we're here for you. But the reality is oftentimes that's not the case. They have to evaluate what their bottom line is in the evaluation of this. They have to also evaluate, are there ways to get you to take less? And like I mentioned with that good hands boxing glove strategy, they hope to wear down certain people that just want to be like, look, I got in a car wreck on the way to work. I'm not trying to get into a lawsuit. I'm not trying to have to go down to court and testify to people. And they know that a lot of people don't want to do that. And they know that a lot of people need money now. So they know if they waive $2,500 in front of someone and they're like, well, my bills were only $1,200, that's fine. I can go ahead and get that done. But if that person keeps hurting, keeps needing treatment, now they're kind of eating their shirt and they're underwater because they're having to pay their other insurance or out of pocket for that treatment. So I think people need to be very aware that the insurance companies oftentimes don't serve their best interest. And because of the way that they're structured, where there's even a human factor removed from it, where it's just a lot of software and data, which they've habitually been told they're not allowed to negotiate that way. And so one last thing people need to consider is this. Insurance companies were told that they had to reuse or refigure how they were using some of that software and data. The response to being told by more than 40 heads of departments of insurance of states that this was not good faith negotiations, need to change your methodologies, was that the insurance lobby started pouring money into the legislatures of states, started pouring money into judiciary campaigns, and started pouring money into tort reform advertisements. So instead of saying, hey, look, we're going to pour this money into paying out these claims, we're going to pay the politicians, we're going to pay for judge campaigns, and we're going to pay for advertisements saying that the plaintiff's lawyers are running up your insurance bill and it's their fault. That's what they decided to do when they were chastised about not negotiating in good faith. So if their approach is to build that kind of narrative in a war chest, as opposed to actually handing you the check you've been giving them money for decades, that should tell you where their mindset of the company is for what's most important to them, whether it's their bottom line or paying out your claims.
So in those early conversations, what are some ways people unintentionally hurt their case just by, maybe how they communicate or maybe how they don't communicate?
I think I hear almost every deposition, didn't you tell my client that you were fine? You told them they were fine, right? And really, if I get in a car wreck, I want to rush over and check sure you're all right. Even if you rear-ended me, the human factor, I want to make sure you're all right, right? I got my daughter in the car or my son in the car. I want to make sure they're all right. I want to make sure I'm all right. The reality, we want to get out of the road and so other cars can by, the people usually not bleeding from their head, not on fire, not having broken bones where they're limping from, are going to say, hey, I'm fine. Like your adrenaline's pumping. You may not even notice. It's a natural reaction. So that phrase, I'm fine, ends up getting just used, weaponized against people all the time. So, you could say, look, hey, look, I'm going to get checked out. It's something simple as that. Or, hey, look, are you okay? Are you sure you're okay? Making sure to do that. So even leaving your dash cam on, recording conversations, making sure any calls with the insurance company are recorded on your end, because they're recording their calls with you. I can promise you that. So just making sure to not commit to any numbers in the beginning. Making sure not to just to not make any exchanges for, let's say, cash offers. Sometimes people be like, look, just give me $200 on the scene. It'll be all right. I've actually been at the scene of a wreck where that occurred, where someone just said, hey, I just want $200 cash. Is that okay? Don't take any offers, make any offers. Don't tell people, hey, I'm fine. Unless, listen, if you're in a minor fender bender where you don't need to call a lawyer, you're not going to file a claim, it's not even worth the deductible. Yeah, sure. Tell people you're fine. But if you have a serious wreck with potential serious injuries, don't use that kind of language. And then I think also failing to get information from the other driver at the beginning. You've got to get their license, take pictures of their vehicle, take pictures of your property damage. If part of your vehicle's come off, take pictures at the scene. If there's skid marks on the road, take pictures of the skid marks that are on the road. If you have police that have come, get the name of the officer, get their badge number, make sure you understand, when they're going to be getting the report, what station do they work at, so you can get the information from them. If you're getting your vehicle towed, you need to get all that information. How much is this going to cost? Where is it getting towed to? Is the insurance company, without me committing to anything related to my bodily injury, are you going to pay my property damage? Because insurance handles those things separately. Bodily injury from property damage. Will you pay for my towing? Will you pay for my property damage? If they agree to an amount on that and it includes a rental, make sure to sign that release or have a lawyer sign that release where it's not releasing all claims to include bodily injury just while you're trying to get your car fixed. So early on, those are big, big things. And again, going to the doctor within 24 to 72 hours.
So Trey, insurance companies often ask for those recorded statements. What should someone understand before even agreeing to that?
It's a script. They have a script. The insurance company, that adjuster probably didn't write the script. It's going to come from what they do. And it's a calculated information gatherer that can help them see if you'll commit to certain things, whether it be liability, to see whether you commit to certain things about, hey, on the severity of the wreck. They often ask you for pain levels, a scale of 1 to 10. And so then they often ask you to severity of the wreck. Give me a scale on that. Okay, were you injured on the wreck? They want a commitment early on that. They want you to start committing to things, and they want, you may at some point evaluate that this did or didn't go a certain way. And so that's a script that they have recorded for their analysis. So you don't ever have to give a recorded statement to someone else's insurance. In fact, I recommend that you don't. Now, your own insurance, you want to work with to some level so they can help cover your car and cover any lack of coverage by the other policy provider. But usually that other policy provider needs to pay first before your own insurance will get involved outside of property damage.
As a claim moves forward, Trey, how does the insurance company decide what it's worth?
Insurance companies will evaluate on a number of factors. I mean, the largest factors are going to be the medical bills. They're also going to evaluate if you have lost wages related to it that you can show, black letter numbers, right? Medical bills, lost wages, lost earning capacity, out-of-pocket expenses. Now, the lawyers also will come in and they'll talk about what's called non-tangible or non-monetary damages. That's going to be have mental anguish from this. This is such a severe wreck. I saw someone bleeding from their head. I heard screams from the wreck. That's caused me a lot of mental anguish, or pain and suffering that people have, or impairment. I'm having to use a wheelchair for 6 weeks, or I've had to have, my arm re-broken and reset. So there's impairment as a result. People may not be able to use their wrists the same. There's certain type of, if you have to have scarring or a surgery on your neck, or if you've gotten burned on the scene, there's disfigurement damages. So the lawyers will have them calculate that. They also look at sometimes the severity of the wreck and what the police report says. If the police report lists a number of factors, and that factors include, hey, they're at fault, they did these things that show they were distracted, they ran a red light, they were drinking, aggravating factors that could cause the insurance company to have more exposure. But their analysis is, how much is this worth? And then once it gets into a litigation or lawsuit phase, their lawyers should be, or someone should be evaluating, what is our exposure level? Do we have exposure for a jury in this jurisdiction to give an award larger than our insurance policy? How much beyond that? So they're also going to evaluate who your lawyer is. They're going to evaluate, does that lawyer try cases? Is that lawyer been practicing for a while? Does that lawyer know what they're doing? Did they just kind of go through the process and do cookie cutter stuff? Or are they actually going to push us and be aggressive with the file? They're also going to evaluate what jurisdiction you're in. Okay, you're in Bexar County, you're in Nueces County, you're in Travis County. How do jury pools compare to other pools there, and what is our risk exposure there? Once you're assigned a specific judge, they evaluate that judge. They have a whole sheet. I used to do defense for employment and construction cases, and on the construction cases I had on insurance, there was a litany of stuff I had to write out evaluating the case, the risk to the actual employer or insurance company or construction entity. And part of that evaluations that I had to give would also be, has the plaintiff had other claims? Has the plaintiff had other medical treatment related to the same body parts in the past 10 years? How does that plaintiff present to a jury, or that person at car wreck? So there's so much that's being evaluated about you, your past, who your lawyer is, where the wreck happened, the severity of the wreck, that goes into their calculations through different phases of the case as it moves through the lawsuit phase.
So to kind of close things out, once numbers start getting discussed, how do those negotiations typically play out? Where do things stall or maybe shift?
Yeah, It really depends who your insurance company is, and it depends who your insurance adjuster is and how they evaluate the case and the lawyer. So the insurance company oftentimes will try to resolve these claims, but they have a lot of claims that they have to deal with. It's not, this is a very broad stroke picture to this, but Texas has not had a single day without a traffic death since November 7th, 2000. Actually, TxDOT has this in the street campaign where they talk about it's been over 25 years since we've had a single day without a death on the road. So insurance companies, when they look at things, they pull this big bucket and they say, we have to pay out claims all the time because other people have been killed, other people in wrecks. Every 57 seconds in Texas, according to the data from TxDOT, from 2024, there's some type of wreck that's occurring in the state of Texas. So they use that sometimes to evaluate ways to not offer you the same you should, no matter the value of your case. I've seen catastrophic wrecks where it's a no-brainer. They should have never had to call a lawyer. They should have just mailed them a check of all the insurance. And I've seen ones where they weren't anywhere near that, where they're offering, larger numbers. But the negotiation process needs to start early. They need to, and what I mean by that is not numbers, but with, hey, we have the evidence on our case. It's strong evidence on our case. That evidence includes clear liability, your client's at fault. That includes clear pictures and evidence of the wreck, the damages from to my vehicle, any bruising that I have, any bleeding that I have, clear medical bills, medical records that demonstrate my treatment, ongoing treatment, and additional needs, whether that's future surgical treatment, whether that's future pain management treatment, and also anything related to any data from the vehicle you may pull, data from their vehicle, photos that are created from not just yourself, but from witnesses, witness statements, getting the witnesses' business cards or anything, any videos from dash cams, getting the evidence you need early and continually sending it to the insurance company makes it to where they have to keep papering their file. Written communications with evidence forces them to paper their file and to continue to evaluate the case. And a lot of times, if it's a good adjuster with a lot of experience, maybe they know how to work around the software data a certain way, they actually want to see good cases with nice people who've been hurt real bad get paid out, but their hands are kind of tied by the company they work for. So if you keep papering the file and making sure the adjuster has the information, that there needs to be that way to get negotiations going. But when you start talking numbers, a demand letter by the lawyer needs to be sent. It's often called a Stowers demand. Stowers is the name of the case law in the state of Texas that essentially allows me to send a demand letter that's unconditional, that's an offer to settle within the policy limits, that shows their exposure outside of the policy limits, that if they don't accept and a jury awards me more than that insurance policy, I can actually collect what's called an excess verdict or any verdict above their insurance policy. But a lawyer needs to draft that with the correct language, the correct formatting within conditions of the Stowers Doctrine and the progeny of the cases related to that. And that's when the lawyer needs to start negotiations at a higher number than would be just at the medical. Okay, you want to start at a multiplier of your medical and lost wages to be able to negotiate down. And you may have such continued treatment that you really aren't able to evaluate it except multiple multipliers of what's happened. If you need a neck surgery, if you have skin grafts need to be done for your burns, those numbers need to start high, but the lawyers will be able to evaluate what's a range that makes sense, that's not so high that it completely blows up negotiations, but is high enough to truly evaluate your case so the insurance adjuster isn't anchored at a lower number. Because whatever number they hear first, they're going to get stuck closer to. And you don't want them to be in a situation where they heard you say, look, I'll take $5,000, and you really have a $50,000 case. And they're saying, look, 3 years ago, you said you're going to take $5,000 before you hire a lawyer. Because I hear that all the time. You sent a pre-litigation demand. You sent a pre-litigation demand for $450,000. Well, okay, 15 people in depositions said that they were negligent. Now the case is $2 million. So there's this ongoing anchoring that's very common in human psychology, where if I tell you there's 10,000 people in Greenland and I tell another group of people in group B that there's 2 million people in Greenland, those people will automatically anchor to numbers close to those numbers. So you don't want your adjuster stuck on something that has nothing to do with the value of the case because you said a number early, because they'll also have given a report. It's not just that they psychologically anchored to the number. The other issue is they may have already told a supervisor, hey, look, we value this at 10,000. We value this 100,000. And now they've given a report evaluating why that is. Well, now they have to tuck tail if the case is worth a lot more, go back and round table it with a group of people, ask them questions. Why in the world did you write this as a $100,000 case? Now you're asking me to pay $700,000. So people don't want to do that at work. So if you negotiate against yourself early, lowball against yourself early, bid against yourself, which is where you make a move against your last move before they made a move, any of those will show kind of a weakness in stance and potentially position you in a bad spot for further negotiations. So keeping those things in mind will help people be in a better stance as far as being able to negotiate and have a stronger position for negotiation.
Good stuff, Trey. Appreciate the time, brother.
Thank you, sir, Evan.
All right. That's it for today's episode of the San Antonio Injury and Employment Law Podcast. If you'd like to learn more about Trey Cammack and his work at Cammack Law PLLC, you can visit CammackLawPLLC.com or reach out to the firm directly. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.